Well, good evening. How are you guys? Hey, Christina. Hey, Jesse and Max, Nick, Tanya. This case, and you know what? I don't think I can even touch this bit about her loss. Did you guys see? Now, I'm not a math person. Yes, close to $1 billion in damages. You guys saw it. I am not a math person, so I was not about to even attempt to do the math there. And I saw a couple of different guesstimates, one from Not Actually Golden and one from Little Girl Attorney, and they were quite a ways off from each other. Hey, Busted Can of Biscuits, Hens, Gelth. They were quite off. Their estimates were really, really different. So I'm not quite sure, and I'm not even going to attempt the math myself. Hey, at the beach. But at any rate, we're talking hundreds of millions of dollars this woman is claiming. Never in her life has this woman been worth that amount of money. Never. This was her highest paid movie ever. And she got paid $3 million. Her highest. Her hair care line is a fledgling, brand new business. There's no way that she can properly estimate her losses because it's not like she was earning a set amount of money all along and then suddenly the sales went down because of this. No, she was opening this business as this movie was premiering. She has no idea if any of this affected it. If anything, I've always said it probably promoted it because it made people go out there and say, oh, I've got to try this just to say how bad it is, or had to have something to talk about. I know I've seen people, content creators, taste her Betty Booze and her Betty Buzz just to do an episode about that. And people have done the same thing with her hair care stuff. If anything, this case made her have more sales. So the delusion, yes, she continues to prove she's Delulu. The delusion this woman has, she sees her successful friends, she saw her husband strike it rich, and so she thought she could do that and use this movie to do it. Because, and I keep saying I'm going to redo the old episode that I did. It was one of my first lives, if not my very first live. But it was about the truth about their Hollywood careers. And I want to come back and do like a recording of it and get it perfect. And now after seeing this amount of money, I really, really want to do that just to prove this point. So their careers in Hollywood were quite sad. Just when hers was about to take off, she married Ryan, the man who was married to Scarlett Johansson and couldn't take it that her career was doing better than his. He was not about to let this woman end up with a good career because he, at that point, his career was so low. He was listed. There were a couple of movies where he was uncredited. Like, that's how bad his career was until he got Deadpool. And so we think, when I heard them described as A-list celebrities, I thought it was weird with her because I'm like, what has she even been in her career? I had seen her in Age of Adeline, and I knew she'd probably done some other things. But even if you look at her IMDb profile, that usually takes what you are the most known for, and that's the cover of your profile. What's hers? Gossip Girl. Every time, Gossip Girl. That is her biggest accomplishment in Hollywood, a cable TV show when she was a teenager. So she has never been an A-list celebrity. She got in on her husband's. And the thing about his career is that we confused prolific with successful. When you see someone is in movie after movie after movie, you assume that they are a very successful actor. But when I actually did a deep dive into The movies that they've made, both of them, by and large, the movies they've been in were huge failures. Blake actually has 2 records that she broke. One is the movie that's lost the most money of all time, and 2, her and Ryan together are the worst superhero movie ever with Green Lantern. They are not A-list. He finally started to make money when he got Deadpool. So what did he do? He took control. He chased away the director. He even chased away the creator of the character itself. That's how he got where he is. And he made a lot of money off of that. But the truth is, their actual wealth came from him selling Mint Mobile and Aviation Gin. That's where he made his money. And so I think she thought she was going to come in here and do a Ryan. What he did with Deadpool, she was going to do with this. This had a sequel already written. I think she thought she was going to become Lily and not only do the written sequel, but if she got in good enough with Colleen, maybe Colleen could keep cranking out Lily Bloom books, or she could just take authorship and have someone else continue to write Lily Bloom books. Who knows? But I think she thought this was going to be her big break, her Deadpool. And in the meantime, she was going to follow in his footsteps as well, the way he did Mint Mobile and the way he did Aviation Gin. She was going to do that with her hair care line, Betty Buzz, Betty Booze. And this all made it fail. And the lawsuit just guaranteed that nobody ever wants to work with her ever again. But to claim these damages based on the ridiculousness of what her career actually was is hilarious to me. I mean, what in the world happened to this woman to make this kind of ego? It's insanity. But here we are, almost $1 billion. She thinks she's going to walk away with almost $1 billion from this lawsuit. It is absolute delusion. And as I have held all along, her attorneys must absolutely hate her to have, and we're going to get into that. We're going to get into that because today is all about Jed Wallace's case having been dismissed yet again. So Blue Jean Baby, New York Lady, my favorite piece of evidence, sadly was not enough to keep Jed in this lawsuit. So I think this is the last time we get to celebrate this magnificent piece of evidence. So it made it to my thumbnail. This is dedicated eternally to Blue Jean Baby, New York Lady. But what does this dismissal mean for the lawsuit as a whole? This is much bigger than what the Blake stands realize or want to admit. Even the ones who are attorneys, and they should understand by the wording in 41 pages of writing, they should be able to see clearly what this means in terms of the rest of our lawsuit. They're saying, oh, this was just procedural. It has nothing to do with the merit, but it has everything to do with how the rest of her claims are going to survive. And it's something, those of you who followed me for a while, you know that I have been saying this for months. For months, I've been saying these are not going to survive and why they're not going to survive. And I have to say that I couldn't help. I wanted to get up and do a chicken butt dance when I saw this, but I couldn't because I was in a car. So I think all of us chicken butts, we should get to celebrate for just a moment. Because we were right. We were absolutely write about this, and I just wanna gloat. I just wanna gloat, but I'm not gonna, but I really wanna, so I might do a little bit. Because the things that I've been saying, and I know because I've had Blake Stans come at me on X. I've had you guys tell me what they're saying. They were scoffing, they were laughing, they were saying, "Oh, silly Cassidy. Why does she think she knows what she's talking about? Blah, blah, blah." But the things that I said, Judge Lyman just said in these 41 pages over and over and over again. You guys, we were right. And we were the only ones talking about that part. So I'm so proud of us. But here's the thing. Where's it going to go from here? Because this was just a jurisdiction thing. What about going to Texas? And I've heard somebody say, your son heard it and started dancing. You know what? That is my favorite song. I love the really, really elegant dances at weddings, like chicken dance. I will always be on the floor for those. But so I've heard people say, "Oh, she can take it to California." I think California is not really an option at all, because California, she's not a resident, he's not a resident, his business isn't there, her business isn't there. What's gonna make it survive California if it didn't survive New York? I mean, maybe she has Blue Jean Baby, LA Lady, like the actual lyrics say, and maybe that can make it work in California, but I don't see how this could possibly survive California. It's, to me, it's a less chance than New York had. So that leaves Texas. And he pretty much made it clear, well, Texas has the same stand as New York when it comes to false light. It's not going to survive. It's not going to survive anywhere because it's a bad claim. So she just spent tens of millions of dollars and almost a year of her life pursuing this man, and it all came to nothing. Did she? Irma says that Not Actually Golden posted a video that made California a possibility. I would never argue with Not Actually Golden. I'll have to watch that and see, but I cannot for the life of me imagine how that's possible. Because if his business operated out of Texas, how do you make that claim? And in order for a defamation claim to stand, you can say, well, where the harm occurred. And that for her would be New York because she's a resident of New York. So I'll have to watch it because I would never ever argue with that woman. She knows her stuff. But yeah, his business was tied to California, but does it operate in California? I'm gonna have to watch that. I'm gonna have to watch that. So not knowing much about his business, thinking of it in terms of just as a Texas business. Oh, street registered in California. Okay. Okay, I did not know that. So was he in California still when this began? Because I think, okay, so Roses is saying it did it at the start and then he changed it to Texas. So if that's the case, and that's a piece of it that I didn't know, then it could. Then it could. So if any of this behavior that she's alleging was alleged to have happened in California, I can see that now. So yeah, so that's the piece that could tie it there. But even at that, I don't know how it will survive ultimately. Although California does have easier laws on some of this stuff, like defamation, and they've got the false light. So it could possibly be more survivable there, but that's going to take a lot of time to. Does she have time between now and trial to squeeze that in? It's really a mess. But if her attorneys didn't hate her, they would have insisted that she file her claims in California. Because some of them are New York attorneys like Michael Gottlieb. He should have been able to say, "Hey, this stuff is not gonna survive here. If we're gonna pursue this, you really, really need to take this out of California, not out of New York." But they didn't, and they just sit there sucking tens of millions of dollars, promising her probably that she's gonna be able to collect all those attorney's fees in the end and not have to pay them. That's that is not, something they can promise her, and it's not looking like it's something she's gonna get. But, yeah, they have steered her wrong and earned their retirements off of this case alone. But the reason I say that it's much bigger than just this jurisdictional point is because he doesn't spend 41 pages discussing this just exclusively for this jurisdiction issue. He's saying a whole lot more, and if you understand and if you're paying attention, you would have picked up on that. And it should really have her attorneys warning her, if they care, and concerned for themselves about the remaining bits of this case, because there's so much more in his wording that can be gleaned from this than just this one little issue of Jed Wallace's jurisdiction. It's so much bigger than that, and it's something that I've been saying, and we'll get to all of those points. But basically, he's destroyed the hopes of so many of her claims, and then the others are California-based, and they're pretty much dead. So this is huge, actually. It's much bigger than Jed Wallace. Let me look at my notes really quick. Yeah, I'm going to go ahead and get into the meat of this. So like I said, this is about this order, document 912. And as a reminder, this is a motion, and I'm sure um, many of you, if not all of you, have already seen this news. And so this is the dismissal of the second amended complaint. This one was purely written exclusively to keep Jed Wallace in this lawsuit when it got dismissed the first time. And he doesn't leave us wondering. He gives us the answer on the first page that it's granted. So there isn't much new that she added to that. Most of what she put in there were the silly tactics that she put in there to try to say that this was tied to New York. One of the new things that she did mention, and the judge mentions it in his order, is that she added this astroturfing campaign in her claims. So astroturfing, a lot of us hadn't really heard that much before. So I wanted to be sure and point out what the definition of that is. It's the deceptive practice of presenting an orchestrated marketing or public relations campaign in the guise of unsolicited comments from members of the public. So I think at the point that she did the second amended complaint, she'd already realized that a lot of her original complaints were not going to make it. So she kind of tweaked it and twisted it a little bit because it was coming out that this was organic. So she changed it to where, oh, they seeded this to create an organic blitz. So instead of saying it all was exclusively put out by them, a smear campaign put out by them, it's they seeded the rest of us to organically criticize her. And so that's what this astroturfing leads to. Thank you, Tanya. She says, can you please break down the blue jean reference? The blue jean baby, why is that my favorite piece of evidence? Is that your question? Because in that second amended complaint, the whole purpose of it was because Jed Wallace was dismissed. And so he told her it was without prejudice. And so that gave her a chance to try to bring it back in. So she amended her complaint exclusively to bring Jed Wallace back in. And one of the pieces of evidence, believe it or not, a literal piece of evidence this woman put in a legal filing was this picture of her on her Instagram saying Blue Jean Baby, New York Lady, which is a take off of an Elton John song called Tiny Dancer. And it says Blue Jean Baby, LA Lady, but she put New York Lady. And she seriously put this in a legal filing because she said Jed Wallace was monitoring my social media. So he had to have seen my Blue Jean Baby, New York Lady post and known that I was in New York. And so I laughed so hard when I read this and saw this. This picture was in a legal document filed in federal court in the Southern District of New York as legit evidence that this man knew she was in New York. And it's just so hilarious to me. Like I've laughed over it so many times, I can't really laugh about it anymore. But the first few times I heard it, I was like rolling on the floor laughing that this was a legit piece of evidence that this woman put in federal court. So that is why it is my all-time favorite piece of evidence. I don't think I will ever love a piece of evidence more than I love this one. I don't think it's possible. Okay, so yeah, this was the point. So they changed it to that this campaign was just completely from them, that this was an organic pile-on. So that's how they describe us, all of us who do not like her because of her actions. It's not really her actions, people. We just don't know better. We think it's her actions, but actually we've been fooled by Jed Wallace and his seeding, and that's why we're here. It's not it's not that this woman and her husband are insufferable. And the thing is, I find Ryan Reynolds more insufferable than her. But yeah, it's not because we have minds of our own. It's not because we know how to judge character. It's not because we don't like to see injustice. It's not because we don't like to see bullies. It's just we've been seeded by Jed Wallace. Yeah, we just don't know better. Poor us. How could we be so dumb? But that's her claim. And with pieces of evidence like Blue Jean Baby, I'm starting to believe it. I'm starting to question my conclusions. Okay, moving on from astroturfing. So now what we have, and we're going to skim through a lot of this because, like I said, it's 41 pages, and I have the newer documents that came out late last night that I want to get to as well. I'd hoped to do them all today, but I wasn't able to do that. I was up most of the night, and then I slept till like 2. So my whole plans for the day are shot. But so what her second amended complaint alleged, besides of the Blue Jean Baby, was that this frivolous litigation designed to create press attention, and they keep saying that, but they're the ones that are always in the press. How much of Justin Baldoni's case has been reported that's nice to him, that's favorable to him in any way at all? Almost none, right? So how do they still keep making this claim that it created press attention? Please point to that press attention, because most of the press attention is written in Blake's favor. But still, in so many of their documents, it's always there. And so he's saying that this is her claim, that he was manipulating public opinion, and that it was happening all in New York. It mentions that the website, the lawsuit info website, that is this one. And it says that They selectively published certain documents and filings in the Wayfarer Party's lawsuit and thereby promoted a public narrative about their New York based retaliatory litigation. Let's look at this again. This is the website as of today. The only documents that have ever been put on here are these two. This is Justin's original complaint, or it might have been the second amended complaint, and the exhibit to that complaint, which was the timeline. Nothing has ever been added to this. This is all that's there. These are publicly filed documents that you can find in a variety of places. So to say that they selected stuff to put on here that would lean towards one specific narrative is so silly. It's two documents, two publicly filed documents. Now, I'm sure when they put it on here, because it was at the very beginning of the lawsuit, this was a federal lawsuit. That means to get access to the documents, you have to go to Pacer, where you have to pay. I get most of mine through Pacer, but you can also get them, and they probably didn't realize it was going to explode the way it has. You can get just about every single document on a free website called Court Listener. But at the time, they probably didn't realize that that was going to happen. Not only that, so many of us are covering the lawsuit. So there are a variety of ways that you can get these things. But I think in the beginning, they didn't know that that was going to happen. And so they put these on here where they would be free. Anybody could access them and they could read them without having to pay because they were very big documents. They were expensive. Well, there is a cap on Pacer. So $3 is the most you'll have to spend on each, but you'll have to spend on the document and the exhibit. So this would be $6. And so they put it here. And from that, they say selectively publish certain documents and filings to promote a public narrative. No, they posted their complaint with its exhibit, and that's it. Then it said that it also contained allegations regarding Wallace's knowledge of the Wayfarer Party's presence in New York at various points. And that's what we talked about. And it's kind of funny. I feel like he can't bring himself to even mention the Blue Jean Baby. He does talk about some of the others that she posted because that wasn't the only one that she posted. She also posted there were some other pictures of her in New York, and supposedly that meant that he saw those things. But another note about these publicly filed documents on the website, you cannot say that a lawsuit document is defamation. You can't. It's not allowed. So there was also it was almost as funny as Blue Jean Baby. There was also in this so-called evidence that Jed Wallace had to have known that she was in New York. She mentions that the time zone was 1 hour ahead of his location in Texas, indicating that they were in New York. And the judge's answer to that later is quite funny. He mentions there's 21 other states in that time zone. So saying a time zone is definitive proof that they knew she was in New York is absolutely ridiculous. It's a huge section of the map is in the Eastern time zone. I think it's probably the biggest of the time zones as far as population. And there it is in all of its glory. The piece of evidence that we thought was going to crack the case wide open. Now, it's mostly review in the procedural history, so we're not going to go through too much of that. But there is this important reminder that this case had already been dismissed and that it was dismissed without prejudice. And so people have asked, why was this one dismissed without prejudice when so many others were dismissed with prejudice? So because it's about personal jurisdiction, this isn't something that's based on merits And basically, when a judge dismisses something for jurisdiction like this, he's telling us, I don't really have the right to make a ruling on this case. I don't have a right to preside over this case. So that's why it's not with prejudice, because if he did it with prejudice, that kind of stops it from being considered anywhere else. But he's saying, I don't have a right to be the judge that oversees this, so he has to leave it open for the next judge to consider. I don't know if I said that right. I said it better in my head than getting it out of my mouth. But it's interesting though, because in his description of why he doesn't have jurisdiction, there is a lot that can be read as far as its survival in a court. And that's, I think, the biggest point of this whole thing. Now, there are cases where it can be a jurisdiction issue that it has been ruled with prejudice, but there's usually a bigger point, a bigger problem, vexatious. It could be something vexatious, or um, what's the other word? Maybe they keep bringing it back and bringing it back, and so he's like, "That's it," something like that. But traditionally, it's granted without prejudice, because he's saying, I'm not the judge to cover this. So he leaves it open for the next judge. And then he mentions due process. We'll come back to that later. But he says the court held that the exercise of personal jurisdiction would violate due process because the amended complaint contained no factual allegations that the Wallace defendants directed or controlled any conduct into New York, or were aware of any actions taken in New York or directed at New York. And so he granted her this leave to file a second amended complaint, because, and that gets to the heart of what I just said. If it was with prejudice, it would violate her due process rights. If it was with, that would mean she couldn't pursue it later. So it would violate her due process right to be heard. So that's why it was done without. And instead of taking the time and realizing this wasn't going to make it, this wasn't going to survive, and heading somewhere else like Texas or California, she tried her luck again here in New York, which again, her attorneys had to have known better and really should have put their foot down and said, no, you need to take this elsewhere. You're just wasting time and money. I mean, they may have, and she may just not listen, but I think if they spelled this out, there's no way it's going to make it. And insisted we don't even attempt this. I can't imagine her not listening to that. But I mean, maybe they tried. I don't know. I just feel like these people don't like her and they're just taking her money. Okay, then we get into the legal standard. The plaintiff, which is Blake, bears the burden of establishing that the court has jurisdiction over the defendant. So basically, the ball was entirely in her court. I mean, Jed Wallace did a brilliant job of defending. Well, his attorneys did a brilliant job of defending him. But really, this all laid with Blake. She had to prove this. And how is that proven? Where the parties have conducted this is a really funny point. Where the parties have conducted extensive discovery regarding the defendant's contacts with the forum state, but no evidentiary hearing has been held, the plaintiff's prima facie showing necessary to defeat, and it goes on to say the claim, we'll get that in the next page. But this is a funny point, because usually motions to dismiss are filed at the very beginning, like what we saw in this case. But this time, this is after extensive discovery. And it's kind of, it feels almost like a jab that this is all she had at the very end of discovery, when she has almost everything. She's still asking for more, but she's gotten everything that she asked for. Ridiculous amounts of discovery, mountains of discovery, almost all of the depositions. I think they still have a few of the expert depositions still happening. And so by now, if she's ever going to be able to prove this case, she should already have what she needs to prove that case. And so I feel like this is almost a jab. Like, you've conducted extensive discovery and this is what you've got. And remember, the prima facie showing, and some people pronounce that differently. That's my preferred pronunciation. That's where you prove your case before the court. So, necessary to defeat jurisdiction testing motion must include an averment of facts that, if credited by the ultimate trier of fact, which is the jury, would suffice to establish jurisdiction over the defendant. So he's saying this isn't like a beginning of the case motion to dismiss. You have everything. You have all of the evidence. And it should suffice to establish jurisdiction. And it doesn't. So let's talk about averment. What is this as far as a legal definition? It is a formal statement. It's not a casual assertion. But it is like, this is it. And it's something that you will support later in the case by evidence. It's a specific fact relevant to the case. You're obligated, once you make this statement, once you make an averment, you're obligated to prove that it's true. And it must be clear and concise and material to the case. Okay, so she has averred that he should be held to the jurisdiction of New York, and she's not been able to prove it. She has not made a prima facie showing before the court that it's true. So he says, while the court construes the pleadings and affidavits in the light most favorable to plaintiffs, we've heard that multiple times. When he reads a pleading, when he reads a complaint, he is supposed to read it with the mindset that it is true, favorable to the plaintiff. What the plaintiff is claiming here is true. There is an exception, and this came up in the Stephanie Jones, Jennifer Abel thing that we just have been going through, where he said it didn't survive because it was conclusory. And I disagree with him on his conclusion that it was conclusory, because to me, conclusory is saying someone was negligent. They were criminally negligent. That's a conclusion. Because saying something is conclusory is like not showing your work. You make a statement, but you don't have facts specific to back that conclusion up. Whereas Jennifer Abel said, it's the who, what, when, why, how situation. When you answer those questions in your claim, it is no longer conclusory. And she did say what Stephanie Jones did, when she did it, and how she did it. But back to this point, the court has to view the pleadings favorable to the plaintiff, except if it's conclusory. If it's conclusion couched as a factual allegation. So she's saying, well, he should have known because he saw these posts on my Instagram that said I'm in New York. She hasn't proven, or she hasn't shown that how that she came to that conclusion. It's just ridiculous. So then he gets into the discussion of this personal jurisdiction. I hope I'm explaining these things completely. If you have questions, write them down, and then at the end of this, we're going to go through and I'll answer any questions that you might have. But so if I'm not making something clear, go ahead and write it down, because I'm not paying attention to chat as it rolls by, just to keep myself on task, because it is a long document. So write it down and save it for me for later. And hopefully I will be able to answer. And if not, I will look it up and answer later. Okay, so we come across two-prong standards all the time in law. If you follow it for a while, you know we've come across many of these. There's something that's decided in a landmark case, and they become a standard, and they're usually at least two prongs. And then after that, all the cases that come later have to fall in line with those two prongs in order to succeed. And so we have that situation here. They're often used to cure deficiencies or to determine something that may be difficult to determine. So in this jurisdiction, it's not surprising that we come across yet another two-pronged standard. So it speaks of non-domiciliary, and for those, that requires this two-part inquiry. The first part of it is whether there's a basis for personal jurisdiction under the laws of the forum state, in this case, in New York. And the second, once, and it's not like they pick one of the two. The first prong is always the most important and usually the most difficult to overcome. So if it overcomes that first one, then it still has to overcome the second one. So the second prong in this is whether that personal jurisdiction comports with constitutional due process. So this is the standard that he had to use, that he had to apply to come to his decision. Now, what she used was CPLR. This is Civil Practice Law and Rules. So whenever you see this, CPLR, and then there will be a number after it, the little section symbol, and then the number after it, these are the civil rules for legal practice in New York. And every state has their own little abbreviation for their particular laws for their state. CPLR is just New York State laws. So this is the standard that she used to try to overcome this first prong. Now, what does CPLR 301 say? It says that if the defendant is domiciled in New York, they live in New York, or has engaged in such a continuous and systematic course of doing business here as to warrant a finding of its presence in this jurisdiction. Now we're going to go a little bit deeper into these rules. So what Blake claimed were three different things, three different parts. One, conspiracy jurisdiction under CPLR 302A2, that the co-conspirators committed tortious acts within New York. Her second claim was personal jurisdiction under CPLR 302A3, a tortious act outside New York causing injury to person and property within the state. That means that they should have expected the act to have consequences in New York. And three, the conspiracy jurisdiction under CPLR 302A1, that Wallace and his co-conspirators transacted business within New York, and that those contacts can be imputed to the Wallace defendants. So we have the law here that she referred to. CPLR 302A, and then we have 1, 2, and 3, and she listed all of those. So what does it say exactly? Let's read it directly from the code itself. That personal jurisdiction by acts of non-domiciliaries, these are people who do not live in New York. A, acts which are the basis of jurisdiction as to a cause of action arising from any of the acts enumerated in this section, a court may exercise personal jurisdiction over any non-domiciliary or his agent who, in person or through an agent, 1, transacts any business within the state or contracts anywhere to supply goods or services in the state. 2, commits a tortious act within the state. We're going to skip the second half of that. 3, commits a tortious act without the state or outside of the state, causing injury to a person or property within the state. So this is what she claimed that she was going to prove with the likes of Blue Jean Baby, New York Lady. Now, there's some really important things to consider about this law. Oh, where is it? These things sometimes look different when I come back to them. I had highlighted things in that law that is not showing up. I don't know why that happens sometimes. But going back to this law, now let's read the second half of 2 and 3. They both say, except as to a cause of action for what? Defamation of character. 3, same thing, except as to a cause of action for defamation of character arising from the act. So it lives right here in the very law she tries to use to say that her act qualifies under New York law. But it seriously says it does not involve defamation. And this is the thing I've been saying all along about New York and defamation. We're going to get really, really deep into that because defamation, New York has more protections against a defamation lawsuit than any other state in the entire country. The protections in New York against defamation are higher than the standard of the Constitution itself. New York is the hardest state to win a defamation claim in. It's not going to happen. They have built a great wall around this state for defamation that is just impenetrable. And when things started to arise in other states, like torts, for example, the false light claim, we keep hearing about false light, and that's one of her big things. Those are torts that have been used that are a little bit more survivable in other states than a straight up defamation claim. And so other states have it, they allow it. New York does not. Now, here's the point I've been saying all along. We're in a federal court here with this case. Federal courts have procedural laws. They don't have a long code of laws like every state does that covers every little harm and cause of action. They are all about procedural, and then they adapt a certain state's law to apply to a case. So like this case, we have multiple jurisdictions here. We have people that live and work in California. We have a guy who lives in Illinois. We have Blake who lives in New York. And then we have a movie that was filmed in New Jersey. So we're talking about multiple jurisdictions here. So even within one case in a federal court, each aspect or branch of this lawsuit could fall under a different state's law for the statutory stuff, not the procedural stuff. The procedural stuff will all fall under federal law. And I did a really extensive video about that because it's kind of complicated. So I had a lot of pictures, I had a lot of examples. But procedural is things like when a motion to dismiss is due, how to file that motion to dismiss. That kind of stuff is procedural. It's those type of rules. But statutory is more about laws. And so you take a state law to consider those things in a federal court. Now, how most states operate, as you know, I've done a lot about South Carolina and some stuff in Texas too. So in those states, there, in fact, Alex Murdaugh's son, Buster Murdaugh, he has a defamation lawsuit right now against Netflix, against Warner Brothers. It's a big group of people, and naturally they're all from different states. He's from South Carolina. He's suing in South Carolina. and his claim was removed to federal court as well, and there was a big fight over which law was going to apply. They fought really hard, some of them, to get New York law, but they said that the harm of defamation is about where it's felt. And where is it felt but your hometown, where people know you, where you are walking around and people are recognizing you. And if they're thinking badly of you, that's where the harm is felt. So, guess what? That court ruled that he gets South Carolina law. That's the way it goes almost everywhere, except New York. New York has built these cases. Like I said, they have a great wall around them. There's a new one, Kinsey, that was applied in this case to ensure that Justin, even though his harm was felt in California for what the New York Times wrote about him, this Kinsey case says, oh no, it's not about where the harm is felt. It's about who has the biggest interest. And because the New York Times has such a big interest, it falls under New York law. And that is, in fact, how Judge Lyman ruled. And it is so outrageously unfair that New York can do this. But this is what I mean. They go beyond the Constitution, beyond any other state. It's a great wall that you cannot penetrate. And that's why Justin lost his case against the New York Times. In another state, he probably would have won. He should have won. But this is what New York does. They get new cases. Anytime something new comes around that you could wiggle away and try to get something done, they find a new statute to put up, a new standard in a higher court to ensure that you cannot sue for defamation in New York. And this is what I've been stressing. These claims will not survive in New York, and people can laugh at me. Oh, she doesn't understand. You can apply California law to New York. You can say you apply California law to New York. You can say it till you're blue in the face. But when it comes down to actually making the decision, it's not going to happen. And we have 41 pages of proof that it's not. They simply will not let it, because every single decision that's made in court leaves a record, and that record can be picked up and used to help other judges decide. So if he were to decide that in this case, that would open up others to make this decision. But not only that, we also, in a previous episode, we talked about binding authority. This has been decided in the Court of Appeals. So he has no choice but to follow it. So there's this long arm statute. Defamation is the exception. It simply doesn't get to survive. All right, now where are we? Okay. So, and here's what it's all about. Separate treatment to reflect the state's policy, New York State, of preventing disproportionate restrictions on freedom of expression. They hold that freedom of speech, it's the most sacred thing. The defamation exception is intended to avoid unnecessary inhibitions on freedom of speech or the press. So even though this is exclusively about jurisdiction, it's so much more, because he's not going to change any of this when it comes to deciding her false light claims and any of her other claims that can even be loosely related to defamation. He's not deciding the merits of her case in this, but at the same time, it's the writing on the wall. All these arguments he's making right now are the same ones, mark my word, that are going to show up when it's time to consider her false light claims and anything related to reputational harm. And you're going to see that because it's the rest of this, the entire rest of this document is just repeating this point over and over and over again. The defamation exception, let this sink in. This is outrageous. This is New York. Protects against situations in which, for example, national publications based in distant states are hailed into New York courts on a libel or defamation claim simply because the publication and accordingly the defamatory statement is available on a New York newsstand. All of these quotes that are in the rest of this document are all about building this great wall around New York and freedom of the press, freedom of speech. None of these claims will ever survive in New York. Crucially, the exception applies not only to these claims labeled defamation, but also to those sounding in defamation. Otherwise, parties would be permitted to evade the statutory exception simply by recasting their cause of action as something other than defamation. I did a whole episode about this. Oh, I forgot to load it. Oh, what did I do? Where did I put it? Oh, silly me. I did the chicken dance and I think I forgot my very, very important one.
Feet are tapping on the ground so light.
Oh, not that one. Not that one. It was, oh, I failed. Okay, what it was. Do you guys, in the one where I talked about this, I said, if it looks like a duck, quacks like a duck, walks like a duck, it's a duck. It's most likely a duck. Do you guys remember? So that's the point. That's the way they look at anything that sounds like defamation. So all of these other torts, like falsely, you're getting into the music. Yeah, it's really good. But that wasn't the right song. There was a better one I found, and I didn't save it in the right folder. So sorry about that, guys. But it was if it looks like a duck, walks like a duck, quacks like a duck, it's most likely a duck. So if it looks like defamation, it's defamation, and they call it sounding in defamation. So things like I said, false light, anything related to reputational harm. New York is like, you remember that, hens? No matter how you dress it up, it's a duck. It's defamation if it has anything to do with reputational harm. So you can use it to try to evade that exception. New York is going to see right through it. A plaintiff may not escape the special rules applicable to allegations of defamation. Look what they call it, through artful pleading. So this is the way they look at it. With disdain. They call it artful pleading. They know exactly what you're trying to do when you try to evade defamation by calling it something else. You can't dress a duck up like a swan and think that New York is going to call it a duck. Or call it a swan. They're going to call it a duck. You can put lipstick on a pig. Exactly. Win a claim, however denominated. And these are quotes straight from the Southern District of New York. Quote after quote after quote. This is how these kinds of claims are considered. A plaintiff, wait, where does it go? However denominated, sounds in defamation. The CPLR's defamation rules apply. Courts thus look to the substance, not merely the name of a claim, to determine whether it sounds in defamation. It's not going to survive, truly. And here we have case after case of proof. So it's a matter of substance over form. It's not what you call it, it's what it does or what you're trying to do with it. The reality and the essence of the action and not its mere name. Here's yet another. New York law considers claims sounding in tort to be defamation claims. This is what I've been saying. Like I said, people laugh. They're like, oh, that Cassidy, she don't know what she's talking about. Well, I've got page after page here and a judge saying that what I said was true. And like I said, it may for now just be about Jed's jurisdiction, but these are the same claims that are going to be brought up to her when he's considering the motion for judgment on the pleadings and when he's considering the motion on summary judgment that hasn't been filed yet. This is exactly what he's going to say. And mark my word, Wayfair is going to take these very quotes and put in their summary judgment. Vivian Baker does put lipstick on it. What is going on? See, I should never glance at the chat because you guys are all so interesting and witty. It always catches my attention. Right, hence it's almost like I knew what I was and what I do talk about. Who knew? Who knew? I might know what I'm talking about. I'm gonna enjoy these for a moment. Just we're all just gonna gloat together. Jillian says you were so right. I thought of you in reading the document. Oh, thank you. Oh, thank you, Christina. Cassidy definitely knows what she's talking about. So, I mean, here it is. So, I think I read the one at the bottom. I'm not sure. I got caught up in my gloating, so I can't be positive. But then we look at the next few pages. Now, the green is all decisions straight out of the Southern District of New York, where this case is. The blue are the binding authority cases. And as I said, these are the ones that have been decided in the Court of Appeals, which is a higher court. Once you have this higher court ruling, the lower courts have to rule the same. So they are bound by these decisions. So it's not just all of the Southern District decisions. Those others are binding. He must. and through these next pages, we're not going to read them all, but we're just going to notice how many times it mentions things like damage to reputation. Indeed, even where a plaintiff alleges business and other economic harms. And that's important. It doesn't matter if she claims she has almost $1 billion in economic harms. That does not make her case any stronger, so long as those harms all flow from the effect of one's reputation. The claim sounds in defamation. If it looks like a duck, it's a duck. And that's how he's going to rule, no matter how many billions of dollars she claims that she lost. That's not going to help her win. It's defamation. And that's how it's going to be seen. Even more, like I said, the blue, binding authority, the green are more cases in the Southern District. The court looked for the reality and the essence of the action and not its mere name. It sounded in defamation. Harm asserted sustained by the plaintiff, injury to his reputation, is precisely the same as that caused by defamation. All of these things. Courts have applied the long-arm statute's defamation exception and thereby declined to exercise personal jurisdiction over claims for, among other things, injurious falsehood. And then it cites this case, this Morrison versus National Broadcasting. This is an old New York case. It's very famous, but probably before any of us were born. It happened in 1967. What was it? It was about, and there's been books written about it. This movie was made by Robert Redford about it called Quiz Show, and it actually had a huge legal impact. It was about a rigged game show. So this show was on TV and it was failing. The sponsors didn't like that it was failing, and so they demanded that something be done to bring in more views. And so something was done. The show was no longer a fair game show, but it became rigged. It was scripted. All manner of mess happened. Not everyone was in on it. Some people came and they had no idea that it was rigged. There was a college professor, Morrison, and he is the plaintiff. Press Your Luck, is that the name of it, or was it just called Quiz Show? That sounds, I'm looking in the chat and I see hens go, maybe Lyman watched your Binding Authority video, Cassidy, and said, I don't want Cassidy's smoke. Maybe. I still think it was all of our talking about him being him acting like Blake's daddy, spoiling her, that made him claim in that hearing that he didn't know who she was. I really think we got to him. But oh, Press Your Luck was another rigged one, but a different show. Thank you, Roses Wild. So what happened is that somehow it was leaked that this show was rigged. And I mean, producers were in on it. A lot of people were in on it. And as funny as it is, it seems so inconsequential that it's a game show. But the results of this, it was a huge scandal. The public felt duped. They felt lied to. The legal implications were absolutely huge. It caused an actual reform in industry standards. Congress met on it. The House met on it. There were House hearings. There were criminal prosecutions. There were legislative fixes. The industry was completely turned around. Congress amended the Communications Act to prohibit the prearrangement of game show outcomes and strengthened rules against deceptive broadcast practices. Broadcast practices, my mouth's not working, to protect the viewing public. That's how serious the public took this. It seems like no big deal. Oh, a game show, they were rigged, they were scripted. But that's how big a deal it was. And yet poor little Morrison, he got lumped in with it because he was on the show. He didn't realize it was rigged, and he was scandalized for being lumped into it. And because he was a professor and needed to keep a certain reputation, he attempted to sue, and he had lots of harm to claim. And it was such a big case that, like I said, it was, Congress amended an act over this. There was legislative reform, all kinds of things. And yet, the New York law is so powerful, even back then in 1967, and it's only gotten more powerful since then, that he was unable to sue because his claims were all centered around defamation. That's how strong it is. So, New York hates defamation, no matter how you dress it up. Way back in 1967. So this continues with we just keep seeing things about reputation over and over and over again. We're not going to read them all because just to save time. But it always comes back to if it comes out of defamation, it's defamation. And so he says the Wallace defendants argue that Lively's two causes of action against them, false light invasion of privacy and aiding and abetting harassment and retaliation, both sound in defamation and thus are exempted. And he says the court agrees. And then he goes into these two claims, with the first one being false light invasion of privacy. Now, she has these not just against Jed. She's got these against the rest of the Wayfarer defendants. So we're looking into the future here, ladies and gentlemen, of what her false light is going to do, how it's going to fare against the Wayfarers. So marketing decisions, moral character, private life, ridicule, scorn, humiliation, false impression, sustained harm, reputation, all these words flying out at us, reputational injuries. It doesn't matter what injuries she claims. If they come from this, they're going to be rejected. And like he says at the bottom of the page, the second page here, he said it's worth noting, and this is like a word of caution, both New York and Texas courts reject the false light tort entirely because it largely duplicates the defamation cause of action. So he's basically saying, look, lady, Don't waste your time in Texas either. Don't mess with Texas. As soon as you cross the border, you see that sign, don't mess with Texas. He's basically telling her, like, give it up. Don't try to do this in Texas. So we're going to see if she's going to move on to California or what she's going to do. I hope so too, Christina. She says, I hope this judge is starting to see her games. I felt like he was finally like venting on this page, just like, it's not gonna happen. You're never gonna make fetch happen. I feel like he was just like, he just like vents on this, and then in the end he's just exhausted. That's how I feel reading his words here. The way he just on and on and on. But it really should be an eye-opener. I don't know if it will open Blake and Ryan's eyes, but it should be opening the eyes of their attorneys, because it just basically says it's hopeless. Yeah, not that we can ever trust in Lyman. What? Not Big Bird. Julianne says, so Big Bird's walking and talking like a duck. Yeah, like sweet and salty Lynn always calls her Big Bird. Yes. She may be Big Bird, but in this court, she's just a duck. Yeah, I've seen a lot of people mentioning that they think this might be a new clerk. That could be the case, or it could just be that he's finally had it. And it's finally getting down to discovery's done. He's given her every possible advantage that he could have given her, and this is all she's got, and it's time to make her face some uncomfortable truths here. Not that I forgive him for the way he's treated Wayfair, because it's one thing to have just allowed everything, but the way he has treated Wayfair. Yeah, we're 9 sanctions in. She's going to sanction the judge next, I think. That's what I put on X when I saw this. I'm like, she's going to sanction the judge for this. Okay. In a false light, it's clearly that of reputation with the same overtones of mental distress as in defamation. And he mentions in the footnote about the parties' dispute which state laws govern the false light claim. It doesn't matter. In the end, it doesn't matter. Even if he says he's going to apply California law, letting a false light claim stand in a New York court puts it out there that others can start applying it. And I really don't think he's going to do it. He pulled in Ezra with all these footnotes. He did. Footnote fetish Ezra with an S. Lively's arguments to the contrary are unpersuasive. I loved that one as well. For one, the cases she cites in support of her position all applied the defamation exception. And you saw that. We read directly from the law, and we did that so you could see with your own eyes that the exception is right there in 2 and 3, plain as day. There's the exception. So how do you state those laws and then go about and just use everything based on defamation? Now, the second claim was aiding and abetting, harassment and retaliation. Similar conclusion. This is the unusual case in which the retaliatory acts identified relate exclusively to efforts to damage an individual's reputation and credibility. So he's saying your entire claims are all wrapped up in your reputation and credibility. And he calls it unusual. He's basically saying you have nothing to claim except reputational harm. Lively's FIHA retaliation claim thus falls back on allegations regarding efforts to cast her in a false light. Allegations which the court has already explained sound in defamation. See what I mean? He sounds like he's venting. The astroturfing campaign, he mentioned that was one of the new claims to her second amended complaint. Still, it implicate exclusively reputational injuries. She framed aiding and abetting centered around efforts to damage her reputation. She asserted, indeed, the whole point of retaining the Wallace parties was so that they could help the Wayfair parties shift the narrative from HR complaints on set to shining a spotlight on Miss Lively instead in an effort to destroy her reputation. Now he's using, yes, that's a huge footnote. Now he's using her own words to just like poke at her. Like, this is what you said. Defendants engaged in a coordinated campaign to destroy her reputation, conceal their own behavior by distracting the public with false narratives about Miss Lively, and discredit Miss Lively in the event she spoke publicly about her concerns. These harms all sound in defamation. He points out that she called it a social manipulation plan, digital manipulation, amplifying negative content, unfavorable reputation, reporters to release stories that would cast Miss Lively and or Mr. Reynolds in a negative light, manufactured content to unwitting reporters, helping to make content go viral in order to influence public opinion and thereby cause an organic pile-on. He concludes the claims sound in defamation. Various negative comments, online vitriol. He just keeps on and on taking her words, putting them on here, saying these are all defamation claims. The fairest reading of these allegations and the Second Amended complaint more generally is that the entire injury complained of by plaintiff flows from the effect on her reputation. I loved him so much on this page. For the moment, I still hate him, but I loved some of the lines in here. And I'm not going to keep reading all of them, but you can see them highlighted throughout here. They all are about her reputation. And this point is really, really important because the timing is hilarious. This came out the day that she put in that she lost almost $1 billion. It is well established that lost business or professional opportunities flowing from generalized reputational harms give rise to a suit for defamation. Her case, therefore, resembles those in which courts have found that claims for intentional and negligent infliction of emotional distress sound in defamation. Now, if you pay attention to these cases, these are not about jurisdiction. These are just about claims that were brought to a New York court and what New York ruled on them. That's why I'm saying this is so much bigger than Jed Wallace's jurisdiction. This is how the court will decide the rest of her claims, anything that even has a whiff of defamation to it is going to all come back to this. The only one I highlighted on this is miss the mark because it's so repetitive. This is what I'm saying. He's just like hammering away at her, just like he's held this in for so long. He's like, this and this, it dies, it fails, you fail, you didn't do it. I feel like that's the whole feeling of this entire thing. And then he goes through these New York rules again. And he outright says, Lively has accordingly failed to carry her burden of establishing personal jurisdiction. And when he covers the judgment of pleadings and summary judgment, he's going to say the same thing. It fails. And then he goes into, and we've already discussed this. We, in fact, discussed it when it was filed at how it just didn't meet transacted business because they just happened to be in New York while they were communicating with Jed. They didn't go to New York to meet up with Jed to sign a contract. They were having contract talks that had begun when they were in New York and that continued after they left. No, they'd begun when they were in California before they went to New York. And they continued after they left New York and went on to Chicago. They just happened to be in New York when they were talking about contracting Jed Wallace. That doesn't even begin to equal transacting business in New York. And then he points out that even when it comes to transactions of business, if you look in the pink, it says that this is construed more narrowly in defamation cases. This is how much they hate defamation. That even in cases where you're trying to see if something transacted business in New York, it's more narrow. They hate defamation. And in defamation cases by contract, the single act of uttering a defamatory statement, no matter how loudly, is not a transaction of business that may provide the foundation for personal jurisdiction. Lively asserts that they participated in a conspiracy. So this is going to kill her conspiracy claim. That their co-conspirators transacted business within New York and that those contacts can be imputed to the Wallace defendants. This is the most important line out of the whole thing. New York courts have never applied such a theory of jurisdiction under CPLR 302A1. You know what else they've never done is let a false light claim survive. It's not even gone to a jury. It's not survived summary judgment. Never. Lively had alleged insufficient facts to establish personal jurisdiction on a conspiracy theory. And so the second step, let's see. Oh no, this isn't where I was at. I thought it was later. Losing my place here a little bit. Okay, yeah, I've lost track of my notes entirely. Yeah, this, just like I said, like after we got to that one page, the whole rest of it was just basically, if it's defamation, you fail. If it's defamation, you fail. He calls, here's where I said we would get to this later, the East Coast time zone. She provides a weak basis for concluding that he was personally aware of the entire range of posts related to the film, that certain messages came from the Eastern time zone hardly evinces that co-conspirators were in New York, as opposed to one of the other 21 states in that time zone. The fact that they were hired while their alleged co-conspirators were in New York for the film's premiere does not constitute transacting business within that state. They were in New York temporarily for a few days to attend a premiere. It was coincidental or fortuitous, just like we said when we saw the initial claim. This was not fundamentally a New York business transaction. They happened to be temporarily in the state. Melissa Nathan, in fact, was not even in New York for the premiere. And that's something that Blake had said, that Jennifer Abel and Melissa Nathan were contracting with Jed while they were in New York, but Melissa wasn't even there. Okay. The complaint further alleges that Baldoni has engaged in stunning duplicity, praising Miss Lively to her face and in public while secretly disparaging her in private and plotting to bury her alongside the truth of his own behavior, which suggests that the Wayfarer parties did not, in fact, use public press appearances, at least not initially while in New York, to tarnish Lively's reputation. He's letting her have it. He's saying, you said this, but that's not so. She also failed to demonstrate that her claims arise from those contacts, which 302A1 separately requires. It's just like, you fail, you fail, you fail. The work wasn't performed there. The claims about the website. In their claim, they say that it was intended for a national audience to spread a narrative. Well, that doesn't make it exclusive to New York. That's another thing that destroys her claim. It simply posts online for public consumption and uses her own words against her again. And then we come back to what's going to hurt the rest of her case, the rest of the causes of action in her case, is that this heightened standard. stems from New York's policy of preventing disproportionate restrictions on freedom of expression. It is construed more narrowly in defamation cases due to free speech concerns. And these are also repetitive. I don't want to spend any time on them. We've already gone almost an hour and a half, believe it or not. I love this line too. If anything, it's the other way around. Like he was not nice to her finally. He says it would be inconsistent with free speech considerations and New York court's instructions to apply 302A1 narrowly in defamation cases. And here's another very, very important. Applying 302A1 in those circumstances would effectively permit an end run around the statutory defamation exception, opening New York courts up to a vast array of out-of-state defendants. Do you understand what that's saying? He's applying it to jurisdiction, but this is not just going to happen with her jurisdiction issue. This is going to happen with all of her claims. Okay, he says it fails to establish personal jurisdiction under New York's long-arm statute. I did a whole video about that. The court need not address the parties' due process argument. So remember I told you it's a two-prong, and if they can't get over the hurdle of the first one, which is usually the bigger hurdle, they don't even bother with the second one because it doesn't matter, because it has to pass both. So if it doesn't pass the first one, there's no point in even discussing the second, which was the due process arguments. Furthermore, in light of the court's disposition of the motion to dismiss for lack of personal jurisdiction, the court does not address the Wallace defendant's arguments that the Second Amendment complaint fails to state a claim for relief or that venue should be transferred. The Second Amended complaint for lack of personal jurisdiction is granted. The Second Amended complaint is dismissed without prejudice to refiling in a court that has personal jurisdiction. And there we have it. So, tens of millions of dollars she spent to accuse this man of being the leader of this campaign against her. And in the end, it's all dismissed. And what is her case without him? So, as we've seen, a lot of those cases cited were not simply talking about jurisdiction. This is going to affect her actual claims, what she has remaining of her claims, and it doesn't look good. Now, when it comes to retaliation, because retaliation in other courts normally is a much easier thing to prove than straight up defamation. It's much easier to prove, except for I started doing some digging in New York, and that's hard too, if they're based entirely on defamation. So even retaliation in a case like this is going to struggle. So I'm still deep diving that. I want to pull up as many cases as I can to back up what I'm saying. But it's looking at this point where I've just started to scratch the surface. It's looking at this point like, even though it's retaliation, which in most other states is easier, in New York, that's going to be hard too. They don't want anything to work around their defamation Great Wall. So, like I said, her attorneys, for goodness sake, they have done her no favors at all. They have just taken a huge chunk of her husband's wealth, and they're going to fail her. The best chance she had would have been to do this all completely in California, but she didn't. And they really should have said, we're not even going to represent you if you do this in New York because it's going to be a waste of everyone's time. But they didn't. They opened their wallets and started filling them with all of this nonsense. I mean, just look at the sheer number of things that they've filed. All of the pages and pages and pages. I mean, I hope at some point we find out how much money they've paid all of these attorneys. When you look, the outlook is so dismal. First hard no in her entire life. Absolutely. They may be able to. They may be able to. House of Chatter says, too bad Wayfair can't sue for. Well, they can't sue for SH. I just saw that, but lost wages. But they may be able to get some fees out of this. She is going to get crushed on her motion. Yep. This is not going to end well. And like I said, so many of the things that I said that the judge said in this page, so I feel so validated and justified. Like I said, this is how I feel. Right? This is where we are today. So, yes, chicken butt dance. We're going to have to make up our own song for the chicken butt dance. Every time we're right, we get to do it. So, farewell, Blue Jean Baby New York Lady. You gave it your best. You were the best piece of evidence that Blake had. You worked really hard. I'm sorry that you failed. And this is dedicated in your memory forever and ever. I wish I could animate this picture to the chicken dance. Wouldn't that be amazing? Okay, anybody have any questions? Because I know I wasn't paying much attention to the chat as it rolled by, just so I could get through. Because with that being, like I said, so repetitive, it gets a little boring, even though it was so exciting. It's just like repetitive. So I wanted to just like plow through it. So I don't know if you guys presented any questions that I missed that you would like answered. If not, I'm going to sign off. I've got to run to the store and get some stuff for dinner. My husband is recreating a dish that I fell in love with in Korea, but we need a couple of ingredients. And then I want to get back to these next documents. I'm still working on some old projects too. But the one thing I wanted to mention is that did you guys all see? You probably all saw that Brian Friedman made a statement to the press, and he can remember every time there's a big decision made in the lawsuit, attorneys can go and make a statement to the press. We went through all of that before when she sanctioned him. I don't know what, 4 or 5 sanctions ago. And we went through the rules for attorneys that they absolutely, after a big decision, they can go to the press and make a statement. Or if the other side makes a bad statement about them, they can go and correct that statement. So he'll probably get sanctioned for it again, but he did make the statement that they didn't, because there was a big lie going around that she won. Again, they're saying this. And he's like, no, we preserved for appeal. So it sounds like there is something in motion. That's what a lot of people were wondering, if his bias was from the clerks, because I said that. So if your clerks are doing your research, if you say, hey, I got this case, I need you to bring me the case law on, and this is what they bring to him to make his decision or even write the thing as he goes over it, he can very much be a judge can very much be influenced by their clerks. and what cases the clerks bring to them. So unless the judge wants to sit down and do all this research himself, which is often not going to happen, he relies on what his clerks bring him. So maybe we do have a fresh new clerk that's got a different take and is presenting the judge with different cases. Okay, let's see. Question: Wayfarer didn't even use these arguments in their motion for judgment of the pleadings, so their arguments plus these could kill her case. Yeah, and they still have summary judgment to write. That was a question from Julianne. For I know sometimes you guys are just listening in, so you asked me to read the comments. Can they still sue for defamation? Well, if they appeal, yes. And he says they're appealing. So let's see. Oh, AI can do that? Animate this? I need to. I am such an AI hater. I really am. I had this guy arguing with me on X last night, and he was asking Grok, is that what it's called, Grok, to help him? And I'm like, sir, I hate AI so much. Grok is literally blocked on my X. So one, I won't be able to even see what Grok says. And two, if you need Grok for your argument, you need to just go to bed. That's what I kept telling him. You just need to go to bed, because it was the dumbest stuff coming out of this guy's mouth you wouldn't even believe. And I'm like, well, that explains why you're a Blake stan. Can Texas rule now? Well, he has a suit against her in Texas. So now she's been fighting to stay out of Texas, but now it's going to look funny if she has to go try to make her claim in Texas. But yeah, we're going to see what happens to Jed Wallace's case there. Texas is a whole nother animal than New York. Oh, I love your icon. Speaking of animal, I love animals. You know what I got to do in Korea that was the coolest thing? I got to hold a meerkat. They have these animal cafes you can go to, and there's one that has all kinds of animals, wallabies and hyrax and meerkats and foxes, raccoons. It's so cool. I love animals. Okay. That is the dream job, Tina, in the last 20. She says, I used to teach the chicken dance at the YMCA. That is living the dream. Absolutely living the dream. What dish? I love Korean food, asked Jill. It is, well, the dish that we had is, I can't remember the name of this one. It's with a B. Some of their food words are really, really hard to remember. But there was one called guoma that's made with clams. But what I loved about it was the sauce. There's this sauce they have, and they put it in several dishes, and it's like got sesame oil, and it's got some wine in it, and it's a little bit sweet and a little bit spicy. It's so, so yummy. And he created that sauce that's like perfect, but we're having it with beef because we don't live anywhere near fresh clams. And seafood's just not the same when it's not fresh. Thank you, Christina. I want to remember to thank you now, because I always forget when I say goodbye. Thank you at the beach. And Irma, Mr. Cassidy is cooking. Yes, he cooks better than I do. We do. Jungle Vet Jill says we need t-shirts. I smear Blake Lively for free. Absolutely. Oh, never apologize, Christina. She says I wasn't as present, but I had a thing I have to do today. Christina is the busiest person I know and still is a moderator for so many of us. She's amazing. But thank you guys in the chat, because you're also amazing. You make it easy because you're nice. Yes, it doesn't explain the way he was in hearings. That's what I say. So I love this little turnaround, and a lot of people have tried to say, well, because of the nature of this claim, he's trying to give her everything possible. And yay for him if he is. that's a wonderful thing if he is, but he didn't have to be a butt to the other side in order to do that. And there were times, more often than not, and in hearings, he was ridiculous, that he was just too much. Roses Wild says the clerks would probably be friendly with Gottlieb. Yeah, maybe they don't have a local this time. But I think judges can sometimes become too friendly with attorneys, and that's a problem. That's not just a New York thing, that's an everywhere thing. And I've got something I've been working on, and a shout out to Chocolate Traveler for some of the stuff she provided to me too on some cases that to come back to this Doe lawsuit thing. And I apologize to you, Chocolate. I know you're waiting for that episode, but I wasn't able to get it finished yet. Poor thing, she fights she fights people on Reddit. I'm always like, don't do it, don't do it. But yeah, she's got someone on hold to post something about that, and I've been holding that up. So let's see. I'm just looking through for any more questions before I go. It is. P says this decision is a sharp departure from his previous decisions. I'm still holding my breath. I am extremely encouraged though by the case law that he cited, and it's not, like I said so many times, I know you're probably sick of me saying it, it's not just going to apply to jurisdiction, it's going to apply to her remaining cases. The ones that can survive because they're not California. I mean, her case just basically got obliterated. And if she has no proof of her SH claims, I mean, forget it. This is done and dusted. It really is. Oh, thank you for bringing that out. Roses Wild says Andy's hearing is tomorrow also. Cross your fingers it's dismissed and she will owe him his costs. Does anyone know if the ACLU contacted him? I really hope they did. They were so nice to help Perez, and it really made a difference. I don't think Irma asked to anyone up to date on Jed's lawsuit in Texas. I don't think anything has happened substantial in that, but if someone hears, be sure to let me know. Oh, cool. You saw a jaguar in Panama. Oh yeah, that's the big cat they still have down there. I used to go to Honduras and they had some there, but like in very remote places, not anywhere near where I was. Oh, yes. Gelt wants to go to Perth and play with the koaka, the happiest looking animals. I hope they're as happy as they look. She is so boxed in legally, even if she wants to settle. And I don't think they're going to settle without a public announcement and apology. Justin, thank you, Justin Smotherman. Press Luck was a guy figured out the algorithm. Oh, the quiz show? Press Your Luck, is that what we were talking about? I did. Oh my goodness, did I bring back cool South Korean skincare products? I did. And they are amazing. My skin has never been so dewy. It lasts. And let me tell you, you know how dry planes are. And flying to Korea from Detroit is almost 15 hours there, but coming back for some reason it's shorter. It's less than 12 hours. So it must be a different route, but also you got the wind behind you instead of flying like a headwind. So that makes a huge impact. So, but still, it's like almost 12 hours. And then we landed, but because TSA is so limited right now with the government shutdown, we were stuck on the plane for like 20 minutes. And then we got to go through. And you know how normally, like, your skin feels like it could just, if there's wind, it's just going to like become dust and blow away. Mine survived, and I had a bed again, and so I'm like laying there sleeping, blanket all over my face, and face on a pillow. Still survived. And then I had some stops to make before I got home. That's kind of a long drive. and got home and just wanted to just pass out, took a hours long nap. Woke up still dewy. This stuff is amazing. It's some kind of voodoo. I was even like, there's a store there called Olive Young that sells things cheaper, and I'm like, I need to get this stuff and see if you guys want it and make that my merch. But it is really good. It is the best. You look, you got me on a whole rant or a whole tangent. Let's see. Wayfarer's reply to her last sanction is due to, oh, that's right. We another docket watch tonight. Oh, I want to so bad. My sister did. Tiffany says I got to hold and play with a baby lion in Mexico. I want to so bad. She was in South Africa or Zimbabwe. I can't remember which. She was in a few places down there. I can't remember which one, but she's got video of it and it was so cute, but I've never gotten to do that. Korean food is bomb. I love it. Roses Wild uses skincare too. It is. It's so amazing. We do have the best community ever. House of Chatter says South Korea is the best cultural experience ever. I love going there. I really do. Tiffany asked, do you get an interpreter for your trip? No, I find there's always somebody who speaks English. Isn't that awful of me? I'm one of those awful tourists that I did learn how to say thank you. I'm not gonna repeat it because I have to read it off when I say it, and I don't have it in front of me. So, but when I was there, I kept saying it enough that I could remember it there. But no, and in French, I can say a little bit just to get by. I can order fish and chocolate and coffee and greet, and that's about it. My accent is terrible. I can speak um sort of Spanish and I can speak sort of Mandarin, but the other places I go, it's I'm one of those like, please speak English to me people, and I'm embarrassed by that. Um all right, let me South Korea's on your travel list. Yeah, I never feel safe flying and I fly all the time. And I fly long flights all the time. And the whole time I'm up there, I'm just like, this isn't natural. I don't belong up here. We don't belong up here. We shouldn't be up here. There's nothing natural about this. If we crash, we're dead. Why do you keep telling us to put our seatbelts on? There's no point. Why do you tell me about my seat turning into a raft? But yeah, I still go. I mean, people die on streets every day too, and we still drive. So that's what I tell myself. Yes, that last conference call, we weren't allowed to listen to the first 40 minutes. We don't know what all happened. Juliet says, why would anyone decorate their beautiful New York pre-war apartment like a Texas barn dominium? She has the worst taste. Thank you for saying that. Thank you for saying that. Because I think she has horrible taste. Like, how can you have that much money and everything you wear, including your jewelry and the way your home looks, is so gross? It's not just gross, it's gross. It's bad. Like, she dresses like an old lady. Like that post about her Halloween costume, and I'm like, "What? Isn't that what she always wears?" And even Ryan had like the same pants he always wears. I'm like, "What? What's different about your costume? You always dress like a weird old lady." Her jewelry. Her jewelry. You know that guy who dresses up like her? He puts the wig and like does the mole and stuff. He is so funny. I haven't seen him for a while. Um I want to tell him, and if any of you follow him, tell him that Cassidy said, I want him to go get a bunch of ring pops and put those on his fingers and pretend they're her rings, because that is what her rings remind me of. Ring pops, or like the little 50-cent machines that you get the jewelry out of, in like the little plastic bubble containers. That's what her jewelry looks like. It's ridiculous. I love big rings, but I like the classy um like silver, or a big piece of jade or some other stone. Like, I don't know, more hipster looking jewelry. The stuff she wears is just hideous. It makes me think of ring pops or the things you get out of the bubblegum machines. And yeah, her place is hideous. Absolutely hideous. And she says her friends want her to decorate. I'm like, no, they don't. No, they don't. They're just being nice. Or maybe you're like, oh, let me decorate it. No, lady. No, just stop it. Rose is Wild, not actually golden, said 250,000 of her damages. Yes, that's what I wanted to say. This is proof positive of how little she cares about her original SH claim compared to how much she cares about people talking bad about her. It is a tiny fraction of her damages. And by the way, these damages are the only ones she can triple. So even if she wins 47.1, which she's not gonna, it's only going to be this amount tripled. But she's not going to win. But that's how little she cares about this. It's all about she doesn't want to believe that people don't like her. Yes, they look like the wardrobe for It Ends With Us. That's what her Halloween costume looks like. Oh, I'll have to wait. Do I have them right here? A Pro Bioderm 3D lifting. That's what I got. That I love so much. I bought the ampoule. It's something you don't use every day. It's like a serum. And I've got to look up. I got the eye cream and then just the regular that goes on the rest of the face. There's a whole bunch to that line, but I know myself. I'm not going to do like 6 different things on my face at a time. So I only got those 3. Right. I like a barn dominium, I'm not gonna lie, but like you said, not in a pre-war New York apartment. Right. They got so much character. Why would you do that? You know, you've got other properties. Do that to properties that are out in the wild, not downtown. All right, guys, I'm gonna have to call it a day. Mr. Cassidy is going to be like, do you want dinner or not? Okay. Yeah, I'm not sure she thinks she can lose either. She's probably gonna keep going with this. I hope she does. Yes! Chris Wildfire asks, have I seen the Murdaugh show? The Hulu? Please, you guys, if you know anything about Murdaugh, if you know nothing about Murdaugh, it doesn't matter. Go to Hulu and watch the Murdaugh show. Mr. Cassidy keeps telling me you need to do a like a live watch. I know we can't do that because of copyright, but I was thinking to do an episode by episode, like a book club, like everybody reads it or everybody watches it, and then we come together and talk about each episode. So let me know, and please leave a comment if that's something you would want to do. And even if it's just a few of us, I love it. I have watched every episode over and over, and I stay up because they play it like around 2 my time. I stay up, and that night that I know it's going to be released, I stay up to wait till this gets released, and then I watch it first. It's the first thing I do, and then I post about it on Instagram. But this latest episode, which is the actual where he does in his wife and son, oh my goodness, did I cry my eyes out for this one. It's so good. They do take, and when we if we do an episode by episode chat, I will explain like what's creative input and what's true, because they do put it in there. Although all the true life things have that. But oh my goodness, it is so well done. She did dress Isabella hideous. All right, guys, I'm gonna have to call it a night. And thank you so much. And it's been a while, so I don't want to go because I love chatting with you guys. But thank you so much for joining tonight. And Like I said, I'm working on these others, and then I have 2 that I've been working on for a long time, and hopefully life will slow down enough that I can get those to you, and the docket slow down too. All right, guys, have a great night. Thanks again, Christina.